Good morning, everyone. Anyone who knows me then knows that when I give a presentation, I always have a picture of my daughter or my daughter's in it. It used to be my cat. And it carried on with my cat until my wife pointed out to me, you do have daughters now, David. Why is your cat still in there? So my cat then got moved off and my daughters came onto the slides. I've got rather unfortunate news today because this morning we had a little bit too much wine last night. This McCarthy special 2018 vintage wine was drunk by my fellow panelists, and none of them have managed to make it today. We were hoping that they would. So instead we've got Ellen here, who you've just been introduced to, and Ellen, she's going to step in, and you may be laughing, but she's actually been to 5 ICANN meetings. So if everyone in this room could raise their hand if you've been to more than 5 ICANN meetings, you can come up as well, because we'll need a bit of help here. Right, slides. I haven't got the slide thingy. Where is it? Just down there. Good, that's the first slide. So there's the vintage wine. That's my bottle. I kept it in the bathroom, nice and cool, as you can see, whereas you're supposed to keep your red wine. And it's also not drunk because I'm on a drink dry February. So this is World Trademark Review, which had an article back in 2012, just before the launch or the application window of new GTLDs. And a super brand was planning to apply. Nobody at that time knew who was applying, and nobody knew who else was applying, which was one of the big issues. And this blog came out spookily on the 1st of April, 2012. But you'll see some very interesting comments there, and one from a certain Jeff Newman, who was supposed to be on this panel but didn't make it, Vice President at New Star, who was talking about this new brand. As you can see there, he says, as you can imagine, over the past years, we've talked to a large number of potential applicants for new GTLDs, but it wasn't until .ellen came along that I truly saw how innovative and game-changing the new GTLD process could be. Even Mr. Russell Pangborn, but then Associate General Counsel at Microsoft. Although I can't comment on this particular application, it's important that anyone applying for GTLDs make sure they've created a thought-out business plan rather than just a doodled sketch they are now following. How could he say such a thing? And even the chair then, Steve Crocker of the ICANN board, and these are true quotes, by the way, these were provided by the people, and he said, never have I seen a more compelling case for brand protection. Ellen clearly fits into our bottom-up philosophy. So that was very good. Ellen was quite young at the time. So this was Ellen, and she was in San Francisco at the ICANN meeting in 2011. This is her calling daddy because she'd heard these new things were $185,000 a pop. And this is Ellen when I said, sorry, love, you can't have a new GTLD at that sort of money, but I will get you a T-shirt. And she is still wearing her T-shirt today, as you can see. And now this is the point where my phone's supposed to ring. Technology. I didn't. This was John's one task. The good bit, I've still got to talk about John's bio, and it's rapidly changing. It's not working. Oh, he's calling. Okay, good. No, I've got service. I've got service and Wi-Fi. We might have to. It was good. Okay, well, this is Ellen's bit. Okay, Ellen, now you have to imagine that the phone is ringing, and phones, as you know, are not allowed to be on, and there's no audience phones allowed on. So the phone's ringing. What do you say?
Daddy, you're not supposed to have your phone on.
There we go. Can you answer it for me, darling? Who is it?
It's John. The panels are coming soon, and they're coming now.
The panel's coming now. Thank goodness they've got up. And here's the panel. We'll stay up here. So what we're going to cover today, we've got the panel now, and as you can see, they've arrived. We're going to have a few key takeaways at the end. I'm going to have a quick introduction on the background of RPMs and where we've sort of come from. John's going to talk about the existing private RPMs, and then we're also going to cover the changes that have been considered in the RPM working group, the ICANN RPM working group. And we've also got another ICANN subsequent procedures working group. So this is all full of acronyms, as you can tell, which we're going to go through. And it's really exciting stuff, I do guarantee it. And we're going to finish off with Christine, who's going to talk about how registry practices can benefit brand owners. So if we now move on to the panel, and I say I've got some very interesting things to say about the panel. Some interesting facts which you don't necessarily have in the program. And we're talking about GTLDs and new GTLDs. There was life before new GTLDs. Now here's Mary. I'll let you guess which one is Mary. So I met Mary back in 2009 on the IRT. This was this implementation recommendation team, which spookily enough, a few of us were on. And it was designed now, put in place to try and create rights protection models for the new GTLDs, as the UDRP was deemed perhaps not strong enough. So Mary is a huge Lord of the Rings geek girl, and she has been since her early teens. She's even tried to learn Elvish once. So you can hear, she's clearly the intellectual amongst us. Interestingly, her engagement present from her husband, she tells me, was a full set of the 20-volume Oxford English Dictionary. Wow. So now that's certainly helpful when you had to read the 8 versions of the applicant guidebook, I suppose. So, and apparently when Mary's not reading her Oxford English Dictionary, she doesn't, don't enjoy cycling. She doesn't cycle very well, but she might enjoy it, I'm not sure. And she can't swim at all, but she's very good at ballet. So there we go. Jeff, on the left there. There we go. He's got the same look on there, you can tell. That's it. Now, Jeff was formerly at New Star, and he's now at the very well-known domain name company Cum Laude. He's well known amongst ICANN attendees as having the worst travel karma that exists. Massive flight delays, luggage disasters, etc. So most people ask, what flight are you going on, Jeff? And then we avoid it. Now, Christine, lovely, isn't that? Born and raised, clearly this photo was taken when you were being born and raised in Minnesota. I've never been, but Christine tells me it's very beautiful, lots of snow, lots of cold, and in the summer months, very humid and full of mosquitoes. She's now at Amazon. It's where she was destined to go to, apparently, having bought her first 3 books in 2001. But before she could lead or land her dream job at Amazon, she went through a few others. So she was, this is your list as well, horse trainer, bartender, cake decorator, Dairy Queen manager. I don't know what a Dairy Queen manager is. We don't have them in Europe, I'm sure about that. Waitress, teacher, and of course her full-time job for 10 years when she was at Forum for the domain name arbitration center. So on to John. Next one's actually not John, that's me. There we go, and there's John. Now, John, I've got to redo this one completely because John didn't manage to call me and destroyed the whole skit we were doing. But anyway, so I'll use version 2 here. So John crashed on a roller coaster when he was 10 years old. And after lying there and after the accident, a man came along next to him. And the man apparently was a lawyer. And he said, "Kid, start crying. I'm a lawyer. You'll get more money if you're crying. Actually, if you could bleed a bit as well, that'd be even better." And apparently it was at that point that John decided he wanted to be a lawyer, just not that sort of lawyer. So that's why John does it differently. So, the takeaways you'll get at the end. Then I'll take them away. So new GTLDs, well, 2012 application window, an opportunity for diversity, choice, innovation, competition. That's what ICANN said at the time. Were they a completely unnecessary burden on brand owners and rights owners? I still think the jury's out. I'm not quite sure. who thinks what, but that's something we can certainly talk about and be interested to hear a little bit later on. What actually happened in 2012, after Ellen called me and said, please can I have .ellen? I said, no, that's why there's no little dot coming out of the UK there. But there was 911 applications from America, 675 from Europe, 24 from Latin America, 303 from Asia Pacific, and 17 from Africa. Here's a smattering of the GTLDs applications that we saw. And a little bit of the numbers. There was 1,930 applications. So that's $357 million US in application fees. So it's quite a bit. It's not your $10 GoDaddy domain name here. 1,409 unique applications, which means there was multiple applications for several strings. That's something which is being looked at in the subsequent procedures. You've got internationalized domain names there. You've got communities. You had 66 geos, 84 .brands, 664, and keywords. So quite a range. As of now, we've got 1,229 delegated. So of the 1,930, we've got 1,229 delegated. Quite a few have been dropped. We've had 566 sunrise periods for brands to tassel with. 557 of them are closed, and there's currently 9 open. I should ask my colleagues to name the 9 that are open. If anyone can name the 9 that are open today, then I think you get a bottle of wine, which is being stored in my bathroom. 339 specific .brand TLDs have been launched. Back in 2009, Francis Gurry, Director General of WIPO, had said that the sale and broad expansion of new GTLDs in the open market, if not properly managed, will provide abundant opportunities for cyber squatters to seize old ground in new domains. And that was the fear, certainly at the time. And the UDRP, as I just mentioned before, was considered that it probably wasn't sufficient. And so this implementation recommendation team was created by ICANN to look at it. And there was a certain character there who you might remember was on it. And there was another lady there who was on it. And there was this gentleman who was on it. And there was another gentleman who was on it. So you can see Russ doesn't think very far when he tries to get a panel together. Now, the solutions to the problems that were there, the cost and administrative burden to react to all of these sunrises was the Trademark Clearinghouse. Trying to create a faster process than the UDRP was the URS, Uniform Rapid Suspension. Then we also had what was called a Trademark PDD. That was to deal with a registry operator that said they would do one thing with the registry, but then ended up doing something else. And THICUIS, which ties in a little bit to GDPR, which we may or may not touch on today, but no single source of data available. Things got a bit tricky. I'm not going to go into these now. We can come back to them if we have time. .wine, .vang, .africa, .merc. Some interesting things going on there. .africa's still going, .merc's still going. .wine and .vang has finally been resolved. And I'll skip through these slides because there's only 2 of them. But as you can see, one of the applicants was my great friend here, John at Donuts, and I was involved on the side of the wine regions. And there was quite a few difficulties there dealing with the whole protection of GIs on the internet when you've got various protection under national, international laws, etc. And can you resolve it within this ICANN process of various applications, objections, requests for reconsideration, even up to an IRP, independent reviews, potentially negotiation. So with that, I will hand over now to Mary.
Oh, I'm going to use this one. This is supposed to have an automatic Elvish translator. It's the Googleplex. Everything is supposed to be possible here, right? But it might be a little bit difficult to speak ICANN acronyms in Elvish, so fortunately for actually me, I'm just going to do it in plain old English. So actually, you can cheat on the answer to David's quiz question earlier if you actually care about having the bottle of wine out of his bathroom, because ICANN does provide websites and pages where we update the statistics as well as all the status of each application and delegation. And we also publish the dates of all the sunrise launch periods and their duration. So if you want to do a little bit of homework, and actually if you want to have an extra bottle of wine, that's some place to look. So I have only a couple of slides because what we found, I think, and I think David, Tom, and Russ will agree, that this panel usually goes best not before lunch, but when we have a lot more questions, interaction, and discussion. So my role here is to speak briefly about an ongoing policy development process that is underway at ICANN. And this is as if we are not ambitious enough in planning for the next round of expansion. We would like to review every single trademark-related rights protection mechanism that's been developed at ICANN. And for most of you in the room, you'll be saying, okay, that means the Uniform Dispute Resolution Policy, dating from 1999, or the UDRP, and the answer is partially yes. But we're not doing that just yet. We launched this PDP in 2 phases, and the UDRP, being the longest running consensus policy of over 30,000 disputes, comes at the end. So we're not there yet, and I know Jeff will have something to say about the timeline, so I'll hold that thought. What we're doing is in phase 1, looking at the rights protection mechanisms that were developed for this current 2012 round. And David's already mentioned the IRT that some of us were members of, where a lot of these protection mechanisms were first developed. And they did go through some refinement in the course of preparing for the 2012 round. If you recall, David said the team was formed in 2009, but we didn't launch this round till 2012. So there's been some changes from the original plan. But essentially, what are these 2012 rights protection mechanisms? David's already mentioned the Trademark Clearinghouse. That in and of itself isn't necessarily a rights protection mechanism. It's more of a framework or a structure. Instead, what happens is that there are 2 specific rights protection mechanisms that are offered through the Trademark Clearinghouse, and that is the ability for trademark owners to essentially pre-register before the general public through what is known as a sunrise registration period. And there is an additional complementary mechanism where if you are pre-registered in the Trademark Clearinghouse, if someone tries to register a second-level domain name, meaning, of course, the domain to the left of the dot, that exactly matches the trademark or trademarks that you have in the clearinghouse, 2 things will happen. The potential applicant will get a notice saying, hello, excuse me, you're trying to register something that matches someone else's trademark. Are you sure? And the person basically has to check a box essentially and said, yes, I'm sure, I'm not infringing anybody's trademark rights, go right ahead, register me. At which point, and there's technical ways about how that operates that John knows much better than I do, at which point you as the trademark owner that's registered in the clearinghouse will then get a notice saying, alert, alert, someone just registered a second-level domain that matches your trademark. So go do something about it. Those are essentially new mechanisms that didn't exist before. So prior to 2012, it's important to remember that essentially on top of regular trademark legal proceedings, all you had that was specific to the domain name system was the UDRP, which, like I said, we'll get to in time. But with the launch of the 2012 round, there were these additional rights protection mechanisms, as well as 1 additional dispute resolution procedure called the Uniform Rapid Suspension Procedure. And that's actually kind of self-explanatory. It's supposed to be fast, and if you win, based on the same substantive grounds that are in the UDRP, you succeed in getting that infringing domain suspended for the life of its registration. So again, this was new to the program. I don't really want to spend too much time talking about the post-delegation dispute resolution procedure. It's a mouthful and it's never been used, so not really much to say with limited time. But the last point I'll make about this phase 1 PDP at the moment is that this panoply of protections that are new really only apply to those GTLDs that were delegated in the current round. And David did show some examples on his slides. So they don't as yet wholesale apply to some of the so-called legacy GTLDs like the .coms and the .nets. Although for some of those older GTLDs, some registry operators have voluntarily adopted some of these into their contractual arrangements if ICANN. So the easier way to remember this is if you're dealing with a GTLD that was delegated before 2012, you might want to check what the contract says about which of these rights protection mechanisms on top of the UDRP. They adopted voluntarily. For anything that was delegated in the current round, everything that I've just described plus the UDRP applies. So we're starting to look at it. We've actually started. We've been doing this for how long? A year? And so these are in the materials. I'm not going to go through that, but we do try to measure progress through milestones and timelines. I just want to draw your attention to the bit on the extreme right, because I think those of you who have attended these sessions before are familiar with the fact that policy development work at ICANN can take a rather long time. And that usually is because you are talking about groups of people working together with occasionally very conflicting interests, including governments, trying to reach consensus on what is appropriate domain name policy. So while we started last year, and mind you, we're only in phase 1 of a 2-phase PDP, our aim right now is to complete the phase 1, which is the new rights protection mechanisms, sometime in the second quarter of next year, which sounds like a long time. If you're sitting in the audience, it probably doesn't sound like quite a long time for the few people I know who are participating in this working group and have the pain of listening to me every single week or twice a week, as the case may be. So I think the takeaway from this slide is watch this space. There is a lot of work that's going on. And for all the RPMs that were developed for the 2012 round, the question obviously is, are they going to stay the way they are for the next round that Jeff is going to talk about? And that's why watching this space is really important. So before I hand over to Jeff, because I think we want to segue into the timeline, I just had a slide on some current challenges, which may partly explain some of the timing that is taking a long time for us to get around. And this is something, the first point is something that I think, David, your work on the Competition and Consumer Trust Review team actually highlighted as well. And I don't think we have time to go into that, but there are some mandatory reviews that we have to go through at ICANN. And David did mention that one of the reasons for having the expanded GTLD program is competition, choice, and innovation. So he is actually, in his spare time, when not storing wine in odd locations, a voluntary member of this team that did point out that for these very important mechanisms, and including the UDRP that's gone on for over 15 years, we don't actually have very good data on how well it works. We know how many cases there are. We can find out what the results are. But in terms of measuring the effectiveness, especially of the new ones, we have no robust, comprehensive source of data. So one of the things that I'm quite happy that the group seems to have coalesced around is that if nothing else happens out of this policy development process, if no one can agree on anything, at least one thing we'll do is ICANN will have to collect data. So for those of you who've done that kind of data gathering work, it's one of those things that sounds simple, but will probably give me lifetime employment. And I don't think I need to talk about the second point, but to segue into the other policy process that is related, and that I think will play a huge role in helping you plan for the next round when it takes place. I guess I'll just leave the slide up here. Thank you, John. And should I just hand it over to Jeff at this point?
Probably to John.
Or to John. I'm sorry. I got the order wrong.
Sure.
I think I need the wine.
No problem. Thanks. And I'll plow through this quickly because, I know we have a time crunch. So ICANN has mandated RPMs, or rights protection mechanisms. Many registries added on their own on a voluntary basis, as Mary mentioned. 3 broad categories. One is, and I'm skipping to the second one, registry restrictions. That's the simplest one for, let's say, a .brand that's not open to the public, that there's no issue with other brands registering names there, or validated restricted TLDs, so like .bank or .pharmacy. For those of us who have generic top-level domains, we have implemented something called the blocking program, and XXX was the first one to do that. Back in 2011, 12, when they first rolled out. And instead of registering a name there, you just block it. Those of us with multiple TLDs provide an opportunity for someone to register a name in the TLDs that they want, and block the names in the TLDs that they don't want. So for example, if David wanted to get hoganlevels.legal, he'd register that, but maybe he doesn't want hoganlevels.plumbing. And so he could just block across all the TLDs that the provider has. And so we have that at Donuts, Minds and Machines has that, and the Trademark Clearinghouse is rolling out with a similar program soon for some of the smaller TLDs banding together. And another rights protection voluntary mechanism is a trusted notifier program. So we do that with child imagery abuse, with NCMEC and IWF. A lot of registries do that with illegal pharmaceuticals, and then even some are dabbling into the copyright area, which has been somewhat controversial. So as far as the DPML goes, again, that looks at the number of TLDs each of the largest portfolio companies are operating with. We're at 239 as of last week because we picked up .travel. So if you want to block your name across all of our TLDs, there's a DPML product to do that, and it's less expensive than one UDRP. So we provide that as a service. Some folks wanted DPML to go a little farther, so we added DPML Plus about a year ago, and that protects not only the exact match or contain. So in DPML, you could have Hogan Lovells or Hogan Lovells lawyer, or anything that contain any mark that contain any term that contains Hogan Lovells. Where with DPML Plus, we added misspellings, and then we tried to protect ourselves against some certain folks who registered names in the Trademark Clearinghouse, like the term love, or most recently blockchain or crypto. And so we made those premium names, and they wouldn't count for DPML. But for DPML Plus, if you want to just block it all, it's just like making a registration in all of our TLDs. You could do that now in DPML Plus. DPML permits overrides for someone with the same trademark. So United, Delta, Delta. And then again, DPML Plus is much more like a registration. If you register it, no one can come in and override it. So those are the functional differences that you can have for your companies or your clients. And then just an example is a trusted notifier program. We did a program with the MPAA. We operate .movie and some other TLDs that they were interested in. And so we work with them on issues of copyright abuse. If it's clear and convincing case, if the new Star Wars movie is out in the theaters and they contact us and say Disney has a problem with an illegal download on one of your sites, we'll take action working with them. We'll give the opportunity of the registrant to be heard. You know, is there fair use? Is there a license or anything like that? But we're not going to make them go out and have to get a court order in such a clear case. And that's been somewhat controversial on the other side of the house at ICANN. So we want to do the right thing, and we want a safe namespace for our TLDs. And that's it. So Jeff is going to talk about next procedures. So.
Okay, so I'll turn this on. I guess I'll wait for the clicker to come over here. But back about 2 years ago, the policymaking body of ICANN, the Generic Name Supporting Organization, started a policy process that we call subsequent procedures, or SubPro. And they came to me and said, do you want to help lead this? It's going to be a small committee, and you should be able to work fairly quickly through these. So I said, okay, sure, why not? You know, what could go so wrong? So they handed over about 150 issues, and I have a committee now of about 200 people, or 200 members and 100 observers. So it's a lot of work, but we're getting there. We're moving. Because it is the policy at ICANN that not only was there going to be the one round in 2012, but that there were going to be additional mechanisms to introduce new GTLDs in a predictable, reliable manner. And so the purpose of this committee is to figure out all the rules so that not only we can do the next round, but also subsequent rounds after that, or even, as some have proposed, doing it kind of on a first come, first served model where it's not in rounds. There's a lot of text on these slides. Hopefully you'll get copies of all these slides so that you can actually read it on your own time. But I'm going to cover just a couple of the key issues which I think affect or have an impact on trademark owners. call it the hot topic or hot issues in subsequent procedures. One of them is, really, should we have additional new GTLDs? A lot of people are asking that question. I'm sure a lot of you are thinking of that question as well. And if we have new GTLDs, shouldn't we just do a brand-only round? Because, that seems like it's a good use of the domain space. And then there's this concept of closed generics. I'll go into that in a little bit. And then there's an interesting clash, which Etienne referenced a little bit, with geographic names and trademarks that's playing out in the domain name space. And then an issue of singulars versus plurals. So first question, should there be additional new GTLDs? Well, the policy has been for the last decade or more that, yes, there will be additional new GTLDs. There's a lot of positives and a lot of negatives, but we held a public comment period, and everyone, including trademark rights owners and others, didn't think that there was a justification in stopping the expansion of new GTLDs. Now, it's cut off, hopefully it displays, it's cut off on one of the screens, but how about some have said, well, shouldn't we open this up to just brands only? So in the last round in 2012, we had a number of brands that applied for their own top-level domains. Things like .aws for Amazon Web Services, things like .microsoft, .xbox, .hsbc, .city, there's hundreds of them that applied. So the arguments for having a brand-only round is it's less controversial. You won't see a lot of the issues. Other trademark owners don't necessarily have issues with AWS using, or Amazon Web Services using AWS for their own purposes, or Microsoft using it for its own purposes, or maybe and Google for its own. Arguments against are, well, wait a minute, some of the brands also have names that could be generic in other or descriptive in other contexts. So although Apple was applied for and is a TLD, let's say it wasn't, if we had a brand-only round and it wasn't delegated this last round, should you only open up .apple for Apple as a company and not for everyone? So at the end of the day, at this point, it's still not a resolved question as to whether we'll start with a brand-only round, but it's something that's being debated by this group. Then there's this issue of closed generics. So in the 2012, what was called the applicant guidebook, which was really kind of the rule book of what applied, there was no prohibition against any company from applying for not only its own name, but for any term it wanted to apply for. And there was nothing in the guidebook that said you couldn't restrict the registrants of that space to only yourself. So if an example we used before the last round was if Kraft wanted to apply for .food, there was nothing to prevent that from happening, and for Kraft using .food only for itself. So a number of brands actually did that. They applied for a generic type word, whether it's Amazon had applied for .book. You had Google applied for .app, and you had a lot of other examples, L'Oreal for .beauty, that proposed initially to just use it for itself and its own affiliates and licensees. There was a number of competitors that either didn't apply in that last round for that term that were not very happy that one company wanted to use that descriptive or category term for itself. And so there was a lot of outcry from a number of companies that said, we don't want that to happen. And so what the ICANN board did is say, okay, we can't figure this all out now. It's too complicated. So for the 2012 round, we are going to say we're not going to allow any of the existing applicants to close their domains to themselves if it's a category term. But for future rounds, we're going to allow the policy process to work that out. So even though it was prohibited after the fact for the 2012 applicants, it's not necessarily prohibited going forward. So right now, the committee is deciding whether to allow companies for applying a category term and closing it, or whether they are going to allow it or force it to become open to anyone that wants to register. One of the more controversial things that's come up, as I said, there was this applicant guidebook that came out with all the rules. One of the rules was that for certain geographic terms, you couldn't apply for them. So if they were country names, they were just off the list. You couldn't apply for those. There were others that said, well, if you apply for a city, for example, and you want to use it as a city, like .Vegas or .NYC or others, then you needed to get either consent from the relevant government or at least a letter of non-objection saying, okay, we don't care if that applicant wants to use it. Well, a whole bunch of things happened where there were a number of strings that were not in any of those categories that were in that specific rule book that governments objected to after the fact. So things like .Africa, which was mentioned by David earlier, .Swiss, .Persian Gulf, .Patagonia, and a whole bunch of others were objected to by governments who said, wait a minute, these are geographic terms. They don't have permission from the relevant governments that in some way own these terms, and still how they justify ownership is a question that's up in the air, but they objected to these. Some of these actually went forward because they were eventually able to work out deals. Some of them are still under dispute and have not yet been resolved. But what's clear is that there are governments now that are pushing that any term, regardless of whether you're a brand owner and you've been using that brand, so something like Mars, right? There's a big town in Pennsylvania called Mars, Pennsylvania, right? So governments are saying if any use of that brand or that term can be considered geographic, government should have the right to object to it, or at the very least, government should have to consent to allow that to go forward. So if Mars wanted to apply, or if Ford wanted to apply for its own top-level domain, it happens to be geographic in many areas. In fact, a lot of brands out there, you have to look up. There's got to be a city or a town or a mountain or a river or a lake or a museum or something iconic somewhere in the world that matches your brand's terms. And there are many governments out there that are arguing that they should have the right, because of some concept of political sovereignty, that they should have the right to have to consent. And this came up as big issues with .bar, because everyone that when the .bar top-level domain was applied for, I'm sure you all thought, your first thought was Montenegro, right? City in Montenegro, y'all knew that, right? Or .spa, right? .spa is a city somewhere in Europe. I forgot where, in Belgium, right? So, obviously you make that association that when someone applies for .spa, they're talking about Belgium. So this really something you should be thinking about going forward is, I may or may not have an interest in, or my client may or may not have an interest in a top-level domain going forward. But if there's that possibility that they do you want to be faced with the situation to have a government somewhere in the world, whether it's town, city, it could be a river, it could be anything of cultural or geographic significance? Do you think that that should be objected to, or have someone object to it based on some other significance, not based on trademark law? And there's a whole work track of this policy development process that's set up just for the purpose of talking about those issues. And then finally, one of the issues I want to talk about, I know I'm going very quick, is to really talk about the issue of plurals and singulars. So when this whole round started, it was a principle that if there were applications that were applied for that were considered confusingly similar to each other, not quite in the trademark sense, but in more of a visual similarity sense, that they would either not be allowed to coexist, or that they would have to be in some sort of contention set. They'd have to work out which one of those is going to survive. But I don't think anyone thought that both the plural and the singular would be allowed at the same time. Suffice it to say, the evaluators who reviewed whether things are similar or not had a very different opinion. And so right now we do have a lot of top-level domains that are the plural and singular of each other, which could be very confusing in a lot of minds of consumers. So we have things like cruise and cruises, and deal and deals, and auto and autos. These are all allowed to coexist. So we're discussing whether that should continue in the future, whether we should be looking at this more from a consumer aspect, and really should we allow both the plural and the singular to coexist. And the argument that was raised was, well, what about things, how do we know whether something's a plural or a singular of each other in different languages? And, of all the complex issues in the world, that's really not one of them. People know that new and news are not plural and singular of each other, right? The term new and news have very different meanings. So we're working on rules that would enable evaluators to know whether something's a plural and a singular of each other. So as far as timeline, This is I put on here best guess, but it's really kind of an earliest. While it may seem kind of far away, it's actually coming up fairly quickly in terms of how things move. If you have a client that may or may not want to apply for one of these top-level domains. So this year in April, this committee that I'm co-chairing will release a preliminary report or initial report out for comment. Comments will be solicited for several months. Then ultimately, by the end of the year, we'll come out with a final report. That final report will then eventually make its way up to the board of ICANN, be approved, and then go out for implementation. So on here it says, and I'm going to push for this timeline because that's something rarely done, but if we're going to put the work in to do this evaluation, so we want to see it actually move forward. So Q1 2021, sounds like it's far away, 3 years away, but it's coming faster than you might think. So with that, I know I'll turn it over to Christine.
Thank you. So I am going to take the unexpected path and come and talk to you some more about domain names. When you hear about Amazon, you think about, top global brand, you think about 2,400 trademark registrations. You might even think about the fact that we've got over 26,000 domain names registered, but really, we are also the second largest domain name registry by number of contracts. We have 52 contracts with ICANN to operate top-level domains. 8 of those are for brand TLDs, and that's predominantly what I'm going to talk to you about today. Because as you're thinking about going forward, and you're thinking about that 2021 date that's looming, and you're thinking about advising your clients about, hey, here's what's happening at ICANN, here's what you need to pay attention to, you need to start thinking about, are we going to and are we not? And here are some things that you need to be considering before you make that decision. So that's what I'm going to talk to you about today, because my role at ICANN is corporate counsel for the domain name registry business. So one of the things that some TLDs do, and this tags on a little bit to what John was talking about, one of the things that some registries do to protect trademarks is they offer other sort of mechanisms, like John talked about the DPML. For instance, we have, For instance, some TLDs offer additional sunrise periods. Most of you are probably familiar with sunrise periods. And I know that David and Mary talked about sunrise a little bit, but that's that sort of window at the beginning of a top-level domains opening where brand owners who have domain names registered in the Trademark Clearinghouse get in first. But what some registries do is they say, well, we're going to extend that. If you have a local trademark, if you're, I think some of the city TLDs said if you're a local trademark, even if it's a common law mark, show us, prove your rights, show us what you're doing for common law mark, and you can get in and we'll get you first in the door. And that's one of the things that some registries are doing to give an extra protection to trademark owners. So as you're looking at ways to protect your brand, and you think of new GTLDs as being a big scary money pit, one of the things to think about is looking at some of the opportunities that registries are providing in order to help protect your names. Sometimes a brand owner or registry operators are also saying, in addition to marks that are registered in the clearinghouse, we're going to allow you in first if you can show that your trademarks are being used in a specific class of goods and services that might be related to that top-level domain and that definition of the top-level domain as a generic word. So those are some of the things that people are doing. One of the things Amazon is specifically doing is we have launched .bot. And I think it's hilarious because we heard the presentation before that also talked a little bit about bots and AI. And if you can read the fine print at the bottom, you can see that .bot is actually in a limited registration period. It's not open for general availability yet. But what we do is we pre-validate people before they can get a .bot domain name. So it's not open right now to just anybody. It's specifically open to people that can prove that they are operating a chatbot. And that's because what Amazon specifically wants to do right now with .bot is build a client base of people who are going to register and use .bot and get people really excited about that new GTLD. And that's one of the things, again, that helps protect brand owners because we're focusing on a specific segment of the market and not just necessarily trying to get people to get defensive registrations. So we're really excited that Beauty.bot launched, and maybe some of you have seen the press release, and is kind of taking it forward with that plan of really launching their website and using it as a bot-related activity. Again, it's the point of it is to be a trademark protection. But what else could you do? So let's say you don't want to participate in these limited registration periods. Some of other TLDs, and John referenced them earlier when he talked about bank and pharmacy, some TLDs say not just limited registration periods, but all of our registrations going forward, even in general availability, will be limited to a specific type of customer or client. And so boats says you have to be part of some specific boat clubs, and makeup says you have to be furthering the beauty industry. And those can be validated like .bot is sort of electronically, automatically at the beginning before you're even given the domain name, but they can also be validated afterwards. A lot of times the registry reserves the right to go in and do a check and continually monitor the fact that you are actually still a member of that association, or you still have that credential that you claim to have at the beginning of that registration. The other thing, and the primary focus of what I wanted to talk about, was really thinking about those next rounds, what you can do to sort of protect your own brand. And the key, as was previously pointed out, is your own brand TLD. I mean, what's a better, safer way to direct people to your client's brand and not even really have to think too hard about defensive registrations? Many of you have probably traveled through an airport lately and seen buildon.aws. Which is something that Amazon is really proud of, and it's one of the bigger marketing campaigns for new GTLDs. And it's one of the big sort of GTLDs in the wild that people talk about. But what do you do when your client says, hey, should we do this? That's coming. We heard Jeff say it's coming down the pike. What should we do? You should really think about what are you going to use it for? Is it just going to be you? You can allow, specification 13 allows you to allow your licensees, your trademark licensees, to register domain names. Is that beneficial? Do you have a lot of trademark licensees that could benefit from using your client's mark? You could choose to build customer trust slowly. I was talking at dinner last night with people about one of the things that my credit union is doing. They didn't switch TLDs, but they're switching the look and feel of their site. And there's been a lot of marketing and emails and little pushes that say we're switching brands. And we heard the panel before us talk about how brands evolve over time. You don't have to make a giant jump to your new GTLD, but you can slowly make that slow push with marketing little bits over time to get your customer to build trust in that brand. And then as you jump to that new GTLD, your client will know and be safe and know that their experience is safer and with the brand itself. Your client's going to need to sign a contract with ICANN. So that's something that you will be heavily involved with. The contract's largely not negotiable. Spec 13 is the spec that you have to sign up that says we're going to limit it just to us as a brand owner or our licensees. You need to think about, this is specifically something Amazon had to think about, whose budget's going to pay? We all the big corporations have lots of different budget categories. Who's going to pay for the new GTLD? Who's going to use it for marketing? Are we going to build our own back end, or are we going to hire someone else? These are questions to think about today before application round starts in 2021, and start interviewing some of these people that can offer that. Will you use it for email? And if so, are you going to think about internationalized domain names? What about universal acceptance? A lot of email browsers don't accept emails with different top-level domains that don't end in ASCII characters, such as that are English characters. So what are you going to do about that if you decide to go with an internationalized domain name? And then who's going to run the ICANN bit? And you think to yourself, well, I've got my top-level domain, I'm good to go, right? But we have a whole team whose job it is to respond to compliance requests, to audits, to abuse reports. We've got to deal with tech issues. What if our backend provider has downtime? We have to be involved with ICANN stakeholder groups, such as the ones that Mary and John and Jeff and everybody was talking about, because you got to be involved in knowing what's happening with your GTLDs. And these are all big considerations and things that your clients are going to need to plan for in the event of a 2021 round. And I think that was it.
Thanks very much, Kristen.
Whoa.
We've got the. You don't need to go anywhere. We're fine. We're done.
Terrible.
You return. Oh, thank you. We've got about 5 minutes for questions. If anybody's got to this panel, please do jump up and ask them anything you may wish to ask.
So you guys said that we may or may not talk about GDRP, and I'm just wondering, are folks anticipating that the UDRP is going to not function for a certain period of time, beginning in May, because we won't be able to see the email addresses on those in the WHOIS inquiry. Won't be able to see that, won't be able to serve, and will we end up relying on the Anti-Cyber Squatting Act when we go after infringers?
That's right, Bully, the one at the end. I'll start because I think that there's clearly a review that needs to be done for a lot of the ICANN policies, not just the rights protection mechanism ones. And you mentioned the UDRP, and one complication there, of course, is that, like I said, the UDRP review isn't going to take place till next year. GDPR, the General Data Protection Regulation, is actually already in force, but the penalties become enforceable in late May of this year. But closer to where we are in phase 1, you've got the Uniform Rapid Suspension procedure, where in your complaint, you've got to list a whole bunch of different things. For example, in submitting your mark to the Trademark Clearinghouse, there's, again, data that's disclosed, collected, stored, et cetera, So we're actually starting to think about that, both internally within ICANN as an exercise across the board, but also with the particular working group, which could add another wrinkle to the many things that we already need to do. At this point, and actually one of my co-chairs just stepped into the room. J. Scott Evans is one of the co-chairs of the working group. So we are talking about how we deal with the GDPR issue with respect to the existing rights protection mechanisms. We don't yet have a way forward, but my anticipation is that that discussion will take place within the working group very, very soon.
Yeah, just to give a little background, GDPR is, I think we talked earlier about it. It's going to impact the WHOIS system. There's no doubt about that. It's either follow the law in Europe and change WHOIS. And so ICANN's coming up with a model for a relatively new, nuanced WHOIS system that we're going to have to implement in May. And every registry and registrar is grappling with that. So the question is, for your perspectives, what do you do with WHOIS that's not going to exist the way it exists today, and how do you handle that? And it's a tough issue for everyone. No one, I don't want to say no one wants this, but no one from the registry registrar side wants this. This is not helping us at all. We're doing a lot of work to be in compliance with the regulations, and we don't want to put brand holders in a position where they can't or have difficulties using UDRP or URS or any of the other rights protection mechanisms that are out there. So it is a tough issue, and we're waiting for ICANN to come out with a model on contractual compliance, and should be next week, actually.
Do we have another question back here?
Can I just add something real quick? I can't tell you exactly when it's going to be published, but very, very soon and imminently is the answer. But what I can say, and I think quite a few folks in this room who, you can say it, I can't say it. Quite a lot of folks in this room will know that the model will likely involve some form of tiered or layered access to WHOIS information and accreditation for folks to access that information, whether you're law enforcement or intellectual property professionals. So that's kind of the broad brushstrokes, and there's a lot of details that we can certainly provide.
Or you could just block all your names and not worry about it.
And I just follow with that. I think with IP attorneys being on that list means there's still a little bit of work left for everybody in this room for the future. David, question.
Yeah, one of the first slides Jeff showed was the question of whether we even should have a second round, and listed pros and cons, and then the bottom of the slide just said there's a consensus that we should do this. And I'd like to challenge that orthodoxy. I think there's a real question as to whether the GTLDs we have yet have really been successful. I haven't seen very many compelling business models on how they're being used, but every one of us in this audience who's either a brand owner or represents brand owners knows that we are spending a fortune on fighting against these things. Or, it's very nice to have the blocking opportunities, but when .xxx or .sucks basically says, pay us tons of money to block your mark in a place you don't want to be, they are essentially running their business models on the back of brand owners. And I think there's really serious questions about the public benefits of the new GTLDs we already have compared to what may yet come. And so I do think there's real questions that need to be looked at. I I think it's very hard with ICANN because right now it just feels like this rock is rolling down the hill and it will be impossible to stop it. But if it is going to happen, I think we should find a way to say to the public, this is actually in the best interest of the public, which includes brand owners, which includes free speech rights as well. There have been a lot of IRPs, decisions that have criticized some of the ways that the first round went, and hopefully those will all be read very carefully and will be taken into account, Jeff, in the committee that you're doing. And yet still ICANN fights the people who have filed those IRPs and doesn't seem to be doing a lot to address the concerns that we've already had. So, you know, I appreciate that there's a lot of thought and a lot of people thinking about these issues, but I'm not persuaded that brand owners' interests, which is ultimately about consumer protection, I'm just not persuaded that those are really being heard here.
Thanks, David.
I think with those words, David, we'll leave it because that's a good end. And we'll move on to eating lunch instead.